Welcome back to our channel. Now we are discussing important judgment. NCLAT clarifies 3-year limitation period during revival of a CIRP application. In revival of CIRP application, where there is a settlement breach and execution proceedings. The question is, can a financial creditor revive a CIRP application if the corporate debtor breaches a settlement? This is the question. Can a financial creditor revive a CIRP application if the corporate debtor CD breaches settlement? How long can they wait before taking action? And does filing an execution case in High Court block your revival rights under IBC? These are all questions. So NCLAT has answered all the questions in a recent judgment in case Metalrod Pvt Limited versus Harshit Finvest Pvt Limited. In the case of Metalrod Pvt Limited versus Harshit Finvest Pvt Limited and others, decided by NCLAT New Delhi. We'll see. This appeal revolved around the revival of CIRP application, originally filed under Section 7 of IBC 2016. We'll see the background. The financial creditor had filed Section 7 application before NCLT, which was admitted. During the CIRP, parties reached a settlement leading to withdrawal of the application under Section 12A of IBC. Later, CD breached the settlement terms by failing to pay as agreed. The creditor approached the High Court by filing a execution application to enforce the settlement decree. Here, this creditor approached High Court by filing an execution application because the corporate debtor breached. Simultaneously or thereafter, the creditor also filed an application before NCLT to revive the original CIRP. But for revival, the NCLT dismissed the revival application, citing limitation and NCLT Rule 48. The matter went to NCLAT. Now the legal issue before NCLAT, whether Article 137 of Limitation Act 1963 applies to revival of CIRP application, whether NCLT Rule 48 can be invoked for such revival, whether filing an execution application before High Court bars the revival under Section 7 of IBC, because this creditor went to High Court for filing execution application. By filing an execution application, whether bars revival under Section 7 of IBC. So if you see the key legal provisions, Section 7 of IBC, this is an initiation of CIRP by financial creditor. 12A of IBC is withdrawal of CIRP application after admission with a 90% COC approval. Then 137 Limitation Act 1963 prescribes a 3-year limitation for application where no specific period is provided, counting from the date when the right to apply accrues. And what about Rule 48, NCLT rules? Allows the tribunal to recall its order in certain circumstances. These are all the legal provisions involved in this matter. We'll see NCLAT observations and ruling. Limitation period. NCLAT held that Article 137 applies to revival applications. The 3-year limitation begins from the date of breach of settlement. So this 3-year limitation begins from the date of breach of settlement, because earlier there is a settlement that is breached by the corporate debtor. So from that day, 3-year limitation period begins. So as that when the right to seek revival accrues. In this case, the revival was filed within 3 years of breach. So it was within limitation. We'll also see NCLT Rule 48. This is inapplicable. Rule 48 is meant for recalling orders in cases like procedural irregularities or fraud. Revival of a CIRP after settlement breach is not recall, but a continuation of insolvency proceedings. Therefore, Rule 48 has no application here. Execution proceedings not a bar. Filing an execution application before High Court does not preclude a creditor from seeking revival CIRP under Section 7. So both remedies can be pursued as they operate in different spheres. One enforces a civil settlement, the other enforces insolvency rights. So the final outcome is NCLAT set aside the NCLT order and allowed the revival of CIRP application. It directed the NCLT to proceed with CIRP from the stage where it was withdrawn earlier. The practical takeaway here is that the creditors, if a settlement is breached, for creditors, if a settlement is breached, you have a 3-year from breach date to seek revival of CIRP. No need to fear of Rule 48. It doesn't block revival applications. Parallel proceedings also possible. Execution in High Court and revival in NCLT can go hand in hand. Always keep clear documentation of the breach, and this will safeguard limitation rights. So we have two channels, RR Corporates and RR Legal Talks. Please do subscribe and hit the bell icon so that you will not miss any of latest updates. Thank you.